You're listening to Parent Projects.
You got a lot that's coming at you. And as part of making the many decisions and when to push in, you've got some serious emotional legal decisions to have to be made. And I'm happy to be back here. We've got session number 3 and segment 3 on this, where we're going to focus on the money matters that have to do with these types of decisions in your parent project. We're going to break down estate planning 101, fiduciary roles in your parent project, healthy contract management. If that's something you haven't done before and you just got a lot of that's coming at you, we sit down with Otto Shill of Jennings Strouss and Salmon again here for Emotional Legal Decisions Part 3, Money Matters. Stay tuned.
You're listening to Parent Projects, a family media and technology group production. Now here's your host, Tony Siebers.
Hi, whether you are looking at the best ways to handle that estate to make sure that mom and dad can go the distance, what happens after they've gone the distance, you're going to start transferring stuff, and you are just, or maybe you just want to minimize the family drama that comes around with it. Otto Shill, thanks for joining us today. We are going to get into this third part of the series. We're going to talk some money matters around those emotional legal decisions. We're going to talk about from estate planning, right, all the way down. You're going to talk to us about healthy contract management and the role of those and the fiduciaries that come and go throughout a total parent project today. Thanks for joining us and doing it.
Good morning, Tony. How are you?
Just blessed. Thank you very much. So let's. You're in a background real quick off of you, Jennings Strouss and Salmon, and your background. For those viewers that maybe missed part 1 or part 2, make sure you check it out off the podcast. Can you give us just a brief background of your aspect and how you come to look at law and what you do with Jennings Strouss and Salmon?
Well, Jennings Strouss is one of Arizona's oldest law firms. I'm in the tax and estate planning department. I'm a certified tax specialist, and I help people with estate planning, business planning, transactions, and employee benefits all day long. So,
love it. Let me find it. There we are. That background, you're not, and tax isn't the only thing that's obviously going on from those things, but you have a personal, we talked about a little in the first couple of rounds of this. You've had personal experiences. You had a parent project. Saw it all the way through, all the way to the end. Times it's awesome, times it's messy, all those types of things. I think one of probably one of the most shocking things that came across, I remember you just really shocking me up, was preparing yourself that at some point in time, one of those decisions you are going to make on behalf of your family member could be that it's going to kill them, right? You're going to make the best possible decision you could possibly do. And the sooner that you could come to grips that is just likely, because death is the natural end state to this, was going to help you process through that. Mm-hmm. That really helped me understand that perspective and just the totality of that perspective for you. You get the emotional side. You understand the soft touch. So mm-hmm. I really value especially as an attorney who's had that and can walk us through. Estate planning, kind of estate planning 101. As someone starting to work, is it a will, is it a trust, advanced, tax planning? Can we break this down? What should a family be thinking about when that first check is, does mom and dad, when you're trying to assess mom and dad, can they go the distance in the first place? What are the types of legal instruments, or what are the types of legal decisions we might have to make or see?
Well, so let's talk. We've talked in previous sessions a little bit about powers of attorney. Mm-hmm. When mom and dad are still alive and you have to act for them, either with respect to their property or with respect to health decisions, appropriate powers of attorney to permit that are important. Mm-hmm. Then when mom and dad finally pass, the point of their property is to take care of them while they're alive. And then if there's something left over, they typically pass it on to family members or others that they choose. There could be some charitable giving or other things, and that requires planning to accomplish that.
So
Go
some
ahead.
of those conversations are, which we talked about before, are probably understanding what's their intent on those
Sure.
things to determine what's the best way to kind of start doing that.
Yeah, although I guess I'd add a caution here, particularly if mom and dad have decided that you're going to be the one who's going to be the trustee of their family trust or the
Uh,
personal representative of their estate. If somebody was going to decide that about me, I would want to make sure mom and dad got to their attorney to do the planning.
yeah,
I probably wouldn't want to be in the room.
and is we sure, and that is a good attorney. I mean, you've got years of practice to put that up, but that's a great one. Putting the brakes on and understanding, oh, if I'm going to be the one to carry this out, then maybe just allowing somebody else to take point on putting it together makes a lot of sense to keep things clean. Is that where you're going?
Yeah, well, not only that, but we'll talk a little bit later about fiduciary
We should know.
responsibility that one is going to have if they're helping take care of parents. Um, in preparation for that, you want to be able to be disinterested to a large extent. You don't want to be subject to the criticism that you influence something ahead of time so that you could get a result afterwards.
Yeah.
So pretty important. And, it's fine to make the arrangements. It just probably better if mom and dad participate with their own attorney in the planning, and you not so much.
Right, right. And that is that probably leads to a good conversation of some of the roles of the types of people that mom and dad might rely on to help put that together to work through those things. So we've got attorneys, accountants tend to get
Yeah,
involved.
I mean, if you have assets of any substance at all, you're going to probably need a good accountant who can help with tax filings. You're going to need an attorney who can help with planning, both estate planning and estate tax planning, maybe gift tax planning as well. You might need a good financial advisor. If assets are more limited, you probably still need at least an attorney who's well qualified to help plan for Medicaid type benefits that are accessible, those sorts of things.
That's so and I think one way to maybe approach this and break this down for those of you at home would be breaking. We talk about breaking the estate planning kind of 101 down into what's the financial plan to make sure mom and dad can get to the end. Then maybe number two, talk to those professionals pushing in with how do we simplify that transition of whatever was excess or left over, or facilitate what mom and dad wanted to do after they departed, if they had special wishes or instructions for any excess, what they didn't need in their lifetime. And then the third, talking about the impact of those people against minimizing the consequences of tax, or how much of that is going to be peeled off or to go away outside of what mom and dad wanted to do with that particular money.
Well, sure. So, for example, it really depends on how complex mom and dad's situation is. If mom and dad have a house, a couple of cars, and an IRA, and they're taking required minimum distributions to live on, and there will be some IRA money left over, a beneficiary designation takes care of a large part of the estate. You have to worry about selling the house and dispersing funds and the cars, but it not as much to manage.
Yeah.
If mom and dad have the more things they have, the more properties they have, the more investments they have, the more complex it gets, the more likelihood that tax will play a role.
Okay.
For example, a lot of people haven't had to worry for the past 7 or 8 years about estate tax or gift tax,
Right.
because back in 2017, the Congress passed the Tax Cuts and Jobs Act, and the credit against gift and estate tax went to $11 million per person. So 22 million per family, and it's gone up higher than that because of the inflation adjustments. Well, in 2026, that's all returning to the $5 million level per person. That's a big gap. So right now people are considering what planning do they need to do now to take advantage of that credit before it's gone, and they're balancing that against income tax issues because they give up certain income tax benefits if they make big gifts now. So the landscape is changing, and more families will be impacted starting in 2026 than have been in recent memory.
So let's break down, then let's talk in that planning of in that type of a stage there. Biggest question I think we see out there, wills, trust at a high level. What is that decision of will and trust? What are mom and dad, if we're new to that and stepping in, we know there are two different ways that mom and dad manage their resources to the end, or what would happen after with those excess resources, kind of in step 1 and 2 of this estate planning 101. What's the primary difference around that?
Well, so we're talking about vehicles that allow you to transfer assets to your heirs once you no longer have need of those assets.
Okay.
There are two different ways to do that. Well, one we just talked about with a beneficiary designation. If you have a life insurance policy and a retirement plan, certain annuities, you can do a designation with that company and it will automatically pass, and you don't need to do more with that piece. Okay. You can, with a spouse, you can do joint tenancy or community property with rights of survivorship, and the real estate will pass to your spouse. If your circumstance changes, your spouse dies, you get divorced, whatever, you may need to change that plan. And then if you need to have somebody else empowered to take care of your property after you die, you can choose in real high level, you can choose some kind of a vehicle like a trust that allows it to be managed over time, or you can do a simple will. The thing to remember is a will is just a piece of paper. It needs to be signed in an appropriate way. There's really only two ways to have a valid will in Arizona. One is that it's a self-proved will. It meets a certain set of statutory requirements. It's signed by the right number of independent witnesses. It's got to be done correctly. Or you can have a holographic will where the dispositive provisions are in your own handwriting. I strongly urge people not to let mom and dad just do that alone. They need competent legal advice, because the consequences of failing to do it right can be pretty significant. Not always.
And what would they be? Like what would significant consequences typically be for something, for failing?
Well, for example, if you die without a valid will, for example, and there are children of mom and children of dad, and mom dies, dad's entitled to 50% and mom's children are entitled to 50%. Whereas what mom may have intended is everything goes to dad. Yeah. Right. So you can change the inheritance scheme pretty dramatically if you don't do the documents the right way. Okay. At the end of the day, though, a will is just a directive executed in the proper way, and then somebody's got to take that to the court. The court has to order the provisions of will put into place. So if there's property, personal property that needs to be transferred, if there's real estate that isn't otherwise titled so that it passes automatically, that a court order has to transfer that. Investment accounts that don't have a beneficiary designation, the same sort of thing. So it's a public process. It can be informal or it can be formal. Informal is just filing the right paperwork, proposing distribution schemes to heirs, and assuming there's no fight, handing out the assets. A formal probate is a litigation proceeding, and it's usually a contested matter, but that's the main difference. And
breaking that litigated meaning it goes to court. It's something where it's likely to end up into court. You're going back and forth between attorneys. You're writing a check to each attorney on each side each time that conversation happens every 7 minutes, right? It's
to be clear, both proceedings are in court. Both are are public record. So theoretically, whatever you have to file with the court can be viewed by anybody who wants to go into the court and rummage through the file. And that's probably the chief disadvantage of probate. But a formal probate is actually a contested proceeding where there are attorneys on both sides trying to figure out who gets what.
Okay.
A comparison to that at a basic level is a living trust, which many people have. And the primary advantage of a living trust is that when you die, it doesn't. And so if you have transferred property to a trust ahead of time, then you've named a successor trustee. When you can no longer be trustee, that trustee can use those assets for your benefit while you're alive, and then can follow the distribution scheme written in the trust to benefit your heirs later on. One important difference is if you have a will and you say $100 to my grandchild, the grandchild's going to get $100. And if they're under 18, the $100 might go to a Uniform Gifts for Minors Act account until they turn 18. But at 18, they get the money. If it's $100, it's probably not a big problem. If it's $2 million, you might not want that result. Sure. A trust, on the other hand, will allow the trustor, the person making the trust, to say, these 5 people get property and here's when they get it. And in the meantime, here's how it's managed. Okay. So for example, a family with young children might want to say the money stays in the trust, doesn't get distributed to anybody until each of the children has gotten the opportunity to go through college. The trustee will consider paying for school books, tuition, right? So you can use a trust to do what you would do if you were not there.
Yeah. Great. And keep that direction. And we're going to, I think when we come back to, we'll talk in those roles of fiduciary roles of those people that are carrying that out as the trustee. I guess one last thing before we go to break, when we were talking on the medical side of the house, we heard and learned that there are some documents that you prep up and you put on that work really well that they're there to help you a lot after mom and dad maybe, or when they're totally out of it, or there are some legal documents that work when they pass. There are others you need to put into place in case they're kind of in and out of capacity from one thing to the other. Is there an impact in a living trust since we're talking about this being access to the capital you need to help mom and dad go the distance? Is there one vehicle that helps families, work mom and dad through their situation easier than others for, taking care of those hospital if they're incapacitated for a year or for 6 months, or maybe it's only for 3 months, but being able to handle who's paying the mortgage and where did this come around? Or is that something that's done there? Or is this an individual decision by decision typically?
People do it a variety of ways and they get stuck sometimes because there's not adequate planning. Typically, a trust will provide a standard by which one decides when a person can't function as their own trustee anymore. Okay. Sometimes you can get mom or dad to agree to that. Sometimes you can't. Sometimes it has to be decided by a court. It varies from time to time. But if mom and dad have discussed it and they've drafted that into the trust, that's the easiest way.
Okay.
But it's always a little tough to know when you're not dealing with a catastrophic event. When is it time to step in and help?
Well, and this is one of the first times maybe to introduce a common theme and a concept we'll have throughout today, which is going to talk through not surrendering your judgment or authority, your autonomy, unless you really have to, unless you know what you're doing when you do it. And for the first time, it really happens for mom and dad, understanding that for them as well, they're looking to not surrender that unnecessarily or before they really feel that they would need to. Is that right?
Yeah, well, sure. And I think that anybody who's gone through this, you and me included, you end up having some conversations with the person you're acting for because they're not ready to give everything up. They might not be ready to give anything up, but maybe dad just needs help signing the checks to pay the bills, right?
Right.
So there, there's some evolution. A couple of things that I wouldn't do. I wouldn't just put somebody on as a co-owner of the bank account, because that's one circumstance where the ownership of that bank account transfers to the second person on the account. Far better to do something in a trust and name the person as a successor trustee than to change your distribution plan by making them a co-owner of an account with $500,000 in it.
Okay. And because then it throws that just takes that off of that. That's almost, okay. Got it. Yeah.
And so I think, again, the point of this is something to encourage mom and dad to do early on with their own advisors. You and I were talking earlier, if I was in the position of helping mom and dad do that, and I thought that I might be somebody who would be in charge later, I probably wouldn't want to be in the room to help with the planning. I'd want mom and dad to do that independently so that I could act independently later on.
That's great. So let's get, we're going to take a quick break here. And when we come back, let's get into that role of the fiduciary, that fiduciary type of role. What's up there? What makes sense from that? How to start thinking about that. Join us in just 1 second as we come back with Otto Shill at Jennings Strouss and Salmon. And we are talking today about emotional legal decision makings, part 3 in our Money Matters conversation. Welcome back, everybody. And that is indeed a highlight of the new Parent Projects Connect. It's our project software to help families that are working their way through either a aging in place, a senior relocation, or an end of life function. Today, we're talking about some of those issues. We've got Otto Shill at Jennings Strouss and Salmon. He's joined us to talk about part 3 in our series of emotional legal decision makings. And in particular, today, we're focusing on those money matters. So Otto, thanks again for joining us.
Sure.
So we started talking through in that estate planning 101, broke it down generally to think it through 3 phases off of that: the financial plan to get mom and dad to the end, the simplified transfer. It then moves into that kind of transfer of those assets that may have been excess or that mom and dad set aside to do works maybe after they were gone, and hopefully doing so with limited conflict. And then in understanding, then the third would be that the impact of the tax consequences. You brought up a good conversation in limiting the conflict of that. If you're going to be a fiduciary, if you're the person who's going to carry out the trust, the trustee or the executor or whatever that might be, it's probably a good decision to detach yourself from that. And best practices of a fiduciary, high level. Let's break into that. What's a fiduciary?
Well, a fiduciary is someone who is acting for the benefit of another, typically. So you're acting as somebody's agent. You're not acting with your own money. You're acting with their money for their benefit. And your obligation, both under the law and under the documents, is to act in their best interest. So there's actually a statute in Arizona that imposes liability if you're in a position of trust and I don't mean just formally named a trustee, but if you're acting in a position of trust with an older adult who's vulnerable, you can actually have liability if you don't act in their best interest.
So this doesn't necessarily have to be a professional fiduciary or an attorney or somebody or an accountant or somebody working on behalf of mom and dad. It can be fiduciary, could be a family member, or it could be
Often is.
okay.
Often is.
Okay.
And, we talked in the last segment about living trusts. And by the way, that's one small slice of a much larger topic about different vehicles,
Right.
both for tax planning and other purposes that could be used. But each one of those vehicles is going to require somebody to administer it, somebody to read it, somebody to do what it says. And that person is not acting for their own behalf, or even if they are a beneficiary of one of those vehicles, they are not acting solely for themselves, but they're acting to benefit other beneficiaries as a class. And so I like to say, as a fiduciary, you don't always have to be right, but you do have to be prudent. And you often have legal requirements about communication and disclosure that you have to satisfy. Your decisions have to be made, as I say, in a prudent manner. So you have to consider the variables. And this is where you and I were talking about the need to never surrender your judgment to anyone. If you're the decision maker, you have to have a reasonable basis for your decision. It has to be reasonably calculated to achieve the stated goals for the beneficiaries of the instrument that you're administering, and you have responsibility for the final decision. That doesn't mean you can't hire an attorney or an accountant or an investment advisor or whoever to help you. You probably can, but you can't just turn everything over to them and never monitor or never care. Now, that doesn't mean you are going to immediately become a financial advisor overnight, right? You won't necessarily have the expertise, but if you don't have the expertise, you have to exercise discretion appropriately to determine who's the best out of several choices to help with those things and why. And it's probably best to document that decision-making process so that you can show that you went through it later on.
That brings a great, so it's a great factor to weigh in when deciding who's going to be the executor or the trustee, and even a self-reflection there. I remember hearing someone we had interviewed before state, you can delegate authority, but you can't delegate responsibility.
Yes.
So that is thinking about that, knowing that you might find that accountant to carry this out, or a financial planner that's going to advise and to work through those things. You still will always have that responsibility. And what you're saying is it makes more sense to have a place where you've documented what you've done, where it's done. In the military, we used to talk about the New York Times test. If they took what you did and how you did it, and that got listed out on the front page of the New York Times, how is that going to come across? Would most people be able to look at that and understand, yeah, okay, that's the most reasonable decision they could have made?
Well, and understand there are a couple of places where this may arise in terms of disputes. One is if you made a decision and it didn't come out right. And if the investment accounts went down, for example, it would be really important to be able to show the steps that you went through to make the proper investment decisions with whoever was assisting you.
Yeah.
The other possibility, of course, is that somebody's trying to influence you to do something, and you just have to resist that. You have to figure out what your responsibility is, and you discharge your responsibility according to the documents in a fair and an impartial manner, and that's your job.
What could you do if, let's say, mom and dad come to you and they're pretty adamant that you're going to be the executor and who they want to handle these things, and you don't feel like that's a responsibility that you want? And you want to offer something else out there? Who would you turn to help professionally, or who could you offer up for mom and dad? What would be an alternative?
Well, there are professional fiduciaries, of course, that you can go to in the community and hire somebody to do that job. It costs money. Sometimes it's easier if there are enough assets to manage that it's financially viable. It may be preferable to hire a professional fiduciary that has investment management capabilities, right? I mean, there are fiduciary companies that just take care of the process, and then there are trust companies whose whole business it is to take financial assets, manage them according to the trust, service the fiduciary, make the decisions under the trust. And if you've got significant assets to manage financially, that may be a pretty good alternative.
I like how you broke that down. Okay. I think a nice, clean, any other roles or anybody in the fiduciary or resources or things you can really think about that'd be really important for a family to consider when looking at those, who the fiduciary might be or how to carry that out?
Well, again, I think that's a decision mom and dad have to make. The problem is mom and dad are likely to initially make it emotionally. My kids will always get along. John knows most about money. And the truth is, John probably does not want to be in the position of making investment decisions with mom and dad's money, either for their benefit or for the benefit of other beneficiaries. So John's going to be best off, if he's named, to find a competent investment advisor who can help take that, or, as I say, find a trust company. But the obligation will arise in a variety of circumstances. If you're named as an agent on a healthcare power of attorney, if you're named as an agent on a general power of attorney to take care of property issues, if you're named as a trustee of a trust, if you're named as a personal representative under a will, if you're named as a manager of a family partnership, all of these are examples of people who have fiduciary obligations. And the key thing to remember is if you're in that position, you have to be prudent and you should surrender your judgment to no one.
Yeah. Well, I want to, when we come back from this last break, let's talk through that. For some of us, we might not have done a lot of contract management or had to evaluate when to surrender some level of decision making or something. So, stay tuned. When we come back from this, we're going to break down just that, great, healthy contract management and understanding those types of things as we talk with Otto Shill at Jennings Strouss and Salmon here in Arizona in the Phoenix market about emotional legal decision making. It's part 3 in our series, specifically breaking down money matters. Stay tuned. I'm Tony Siebers. I'm the founder of Parent Projects, and I'm going to take you on a quick tour of the organization. Come on. The organization is full of surprises. And if you've seen one parent project, you've seen one parent project. So generally, we just try to be mission-driven, objective, virtuous, empathetic, and dependable. We call it being moved. Come on and let me show you the inside. So our organization lives inside the Arizona State University SkySong Innovation Center in Scottsdale, Arizona. It gives us an opportunity to be around a lot of creative people. And creativity, well, sometimes it turns into trouble, but most of the time it's going to turn into quality content for you. I just want to take this moment to tell you we're pleased to have you here. We look forward to helping you. If there's anything at all that you need, please reach out. Follow us on the other socials that you like best and the platform that's your favorite. And until you and I get an opportunity to talk one-on-one, behold and be held. And welcome back. This week, we are concluding, this is part 3 of our series in emotional legal decisions with Otto Shill of Jennings Strouss and Salmon in the Phoenix market. We're talking specifically about those money matters at just a high level. If you are joining us from another state outside of Arizona, you're going to look for an attorney that's in your particular area. We want to be always really cautious with our guests and thankful for us stepping up, but understanding that things do change from one state to one state. And so it's something that we want to stress to make sure that you're talking with somebody in your particular area. Hey, Otto, again, thanks for joining us today. We've gone through some of those just high level estate planning 101 type things and breaking it down. how do you get mom and dad to the end? How do we simplify the transfer of those assets with minimal, hopefully, family drama, family conflict, or problems between us? We talked about a bit in the minimizing the tax consequences, the role that played. We talked about the roles of an expert when particularly a fiduciary, and the roles of fiduciaries and those experts that might step in, what we could be looking for, the responsibility we hold, and yet versus the authority that we might turn over. Now you come down. We've had this constant thing of not only our mom and dad, should they be encouraged not to delegate or to surrender their judgment to anybody until they really have to. We would want to take on the same thing as we're advising, or we take on those roles. Let's talk about healthy contract management. Those times in which we know we're going to have to engage someone. Oftentimes, a senior relocation might be, but it could be 10 to 12 different industries of people that are going to put some level of contract together that you're looking at, right, when you're dealing with a parent project. What are some of the basics we should think about in contracting with people where we're going to turn over some level of authority or guidance?
Well, I think the most important aspect of that is having a good process for selecting who you're going to use to help you, and realizing what their motivation is, what they add, and what they, what's beyond their scope. So it depends on every situation, but for example, a lawyer or an accountant is somebody who you pay for advice. They don't have any interest in your matter financially. They just are they're paid to give you good advice. And that doesn't mean they're going to solve your problem necessarily. And again, don't surrender your judgment to anybody, but they can learn about your circumstance, and they can understand your documents, and they can help you know the consequences or likely consequences of different courses of action. They can help you plan those. They can, you don't need to learn the tax code to, you can hire somebody who knows the tax code and can help use that knowledge to help you make good decisions, but the decision remains yours.
Yeah.
Well,
I think there's to add the flavor or a context to that too. Now you're not just even talking about attorneys or even money managers. Now you start entering others like the real estate agents that you might have to engage in.
Sure.
And then even understanding that obviously one thing we do, which is absolutely indicated up in the corner with our Parent Projects Verified program, right? We're looking not everyone who what they do is we particularly tracking the impacts of being age friendly or working at those end of life type issues or those later. They may have a specialty at some other edge. So this would be one of those times to make sure that at least that umbrella of understanding of the emotional impacts and what that looks like and how to recognize signs of abuse or misinfluence or other things, and to know how to appropriately respond would be important. That's what we do with the Verified program, is we highlight those professionals that do that. I look at a contract. I see a lot of contracts in my life. It's something I've spent a lot of time doing. I actually weirdly
I'm so sorry.
I enjoy contracts. I don't know why.
We need to get you help.
I think so. I enjoy law. I enjoy reading law. I enjoy reading contracts. But in that, you and I are having a conversation before about what you're really doing for that. I mean, I don't pick it apart to be. Rarely am I going to get an opportunity to make a change in a contract. There may be a couple times I've gotten away with lining through something in general. I've been like, I don't like that. But let's talk through when I know what I'm looking for when I read a contract. You're the attorney, and this is your job is to mitigate risk across the board. That's what we count on you for. You're trained for it. What are the parts of context that you bring? What should we be thinking about when we're reading a contract in general that's thrown to us or laid in front of us?
Well, so you're talking about a written contract, and a contract is simply the way people define their relationships in the business world. So you can have contracts with the healthcare providers or the hospitals that you use. You can have contracts, if you came to me, you'd have an engagement letter, which defines our relationship. If you hire an investment advisor, you might find they want you to sign a document that gives them the discretion to go in and out of investments. There are a lot of different contracts, and they define your relationship. They define who pays whom for what. They define what happens if there is a dispute. They outline, if they're well drafted, all the aspects of the relationship. Sometimes you don't have a lot of choice, right? If you want a bank loan, you're going to sign the document the banker puts in front of you most of the time. Sometimes there's opportunity to negotiate, but not all the time.
I like the point of usually being tied at some level to the payment model or the way that people are compensated. And in fact, so there's a contract has some specific characteristics it needs to have for a document to kind of fall within that, right? To help people understand that. The payment model in the past, when I've had a question on something, or if I have a question in it, I would bet usually, if it's not nefarious, and most of the time it's not. Somebody's not trying to go out. They're not trying to get me. It usually tends to be tied to the way that they believe the money would need to flow in order to happen, and that could be complex, right? Especially if they get paid. In some instances in this, you may do business with somebody who doesn't get paid by you. They get paid, by the housing locator group. They might get paid. They get paid by another place where you land, or someone else steps into Medicaid or Medicare or something to that nature, right? There's an impact there in that language.
Sure, and how people get paid is a strong motivator for them.
Yeah.
Couple things to keep in mind. One, in a day where you can get a little bit of information by picking up a telephone, it's important to be careful not to assume you know everything you need to know. You only know what you know, and you don't know what you don't know. So having the right advisors for complex circumstances is important. The other thing that I think's important to realize is, if there's a flaw that I see relatively consistency in contracts across the board, it's a lack of specificity about what the parties will do. They know, they've talked, it's in their minds, but the words don't convey the level of specificity that they expect from one another, and that's where the fight happens later on.
Yeah, I've heard that in real estate, we call those agree to agree clauses, where they just are bad. they turn, we're going to agree that we're going to agree when it comes down to that. But I remember somebody else telling me, like, for a contract in a business or setting up, you need to think about the end. If you think about the end, if all conflict, what are the highest likelihoods that there's going to be a problem, that a good contract is really developed to walk through that. If we don't agree on this type of a thing, this is how we'll settle that. If we don't agree on this type of a thing, this is how we settle that. Is that
but even, I mean, those things are very important, right? You plan the divorce when you're planning the marriage, so that you know how you're going to get in and how you're going to get out. But beyond that, just knowing what the parties will do for one another is pretty important, right?
Yeah.
If you haven't had a detailed enough discussion, a good example is a shareholders contract for the owners of a corporation, or an operating agreement for a limited liability company. That document is the place where, if you own a company with somebody, you would document what the responsibilities, so that you don't have to worry about what happens if one of the three owners decides to stop working as much, right? Who's going to do what for whom, when, how's it going to happen? How will people be compensated for it? If somebody wants out, how do they get out? If somebody dies, what happens? All of those details, that's just an easy example, but all of the contracts that you're faced with are important, because they define that relationship. Some are simple. You bring me this, I'll pay you that, we're done until I hire you to do it again. Some are not so simple, and some are ongoing relationships with higher levels of expectation about performance and what somebody will do.
So the that crux of where you're really getting is in that healthy contract management. Read it, have a level of understanding to it. If I have a question about it, I can ask them about it. Yeah, just
Yeah.
ask them in plain language to maybe explain it to me a different way. Make sure you've got good clarity, and make sure that you've gone to the right level of specificity about how we'd handle those. Is it easier to add language to a contract than to take something off of that in some cases, in your experience?
That depends on who you're dealing with.
Okay.
Sometimes yes, sometimes no.
Okay.
One other thing I would add to this discussion is I learned a long time ago, if somebody can't explain it to you in pretty plain English, there might be something wrong.
Okay.
And I think it's important that if language in the contract is too convoluted or too hard to understand, it's just an opportunity for a misunderstanding.
And I really like that you went off of that, and you claimed that, or that's where you went with that, because I've run into that as well, professionally and personally, and it wasn't a nefariousness about the other person. It simply was they didn't even understand the document, and that could lead to just as much of trouble between us,
Yeah.
as it being something that was going to work against me, where they were trying to get me. That was less of an issue, honestly, in this thing than the fact that both of us didn't really understand the document that we had in front of us.
Well, and remember too, if you're in this, you're oftentimes acting as a fiduciary, as we talked about earlier. And so entering into agreement is a fiduciary act. If you're not careful enough about reviewing it or getting advice about it, then you may have liability if you make a decision or take an action that doesn't turn out right.
Yeah. That's probably a great place to kind of tie a bow against all that. There's a million places we could go off of all this, and I'd expect maybe to get into some of these details in other episodes that you and I get a chance to sit down and talk to. Where should people go to look to find an attorney in their particular state? Is there a great quick place to start on the estate side of the house or dealing with this type of stuff? Anything that you recommend?
Somebody, often people can get from word of mouth, they can get ideas about who other people have had good luck with. Kind of need to find referrals that have your level of need and concern. State bars will often have referral lists that they can use. The Arizona, like other states, has specialization certifications. For example, I'm a certified tax specialist with the state bar. So you can go there and you can find people who have pursued a certain course of study, have a certain level of experience, and taken some testing to qualify for that designation. But often it's just who you know and who's had good luck with other people. So
great. Last question against that. If your family lives in different states, what is really the driving when you're going to engage off of that? Let's say you got a sibling that lives, we have a sibling in Florida, a sibling in Arizona, mom lives in Kansas. Talk me through what is the state that we're going to want to get that we're going to want to seek, the legal counsel and the accounting and that work off of.
Well, if mom's doing the planning, you're going to need to do it in Kansas. That's where you said mom lived, right?
That's right. Yeah.
Trying to follow the map around.
Yeah.
And that means, maybe you start with whoever here to see if they have a relationship. So our firm, for example, has a relationship with mid-sized firms around the country. And if I needed somebody in Kansas, I would look first to a firm that we have a relationship with. But other people have similar types of cross-referral relationships. It's a little hard when you just don't know anybody. You can't just drop into town and call someone. The other thing I would add is just because you get a referral, don't just settle there. Interview 2 or 3 people and understand who people are. At the end of the day, any professional relationship you're entering into with an advisor is going to be a personal relationship, and you have to figure out who you can work with and how you communicate. And so getting 2 or 3 possibilities is probably a wise way to go about it.
That's great. That's great. Otto, I really appreciate the time you've taken with us against this entire series for emotional legal decision makings today on money matters in particular. And the previous episodes, you guys can check those out. And then, let us know, where can they find more for you, Otto? Where does everybody here in Arizona find you?
Well, you've got our website up. My name is Otto Shill. My email is oshill@jsslaw.com. And the phone number for the firm is 602-262-5911. So feel free to call.
Wonderful. I appreciate it. Well, Otto, thank you again. As we broke down again in this episode, this is estate planning 101, our fiduciary roles and how that plays into our parent projects. Finally, healthy contract management. That was a mouthful. And I really appreciate the time you took today to share your time, talents, and treasures with us. Thank you so much.
Thanks for having me, Tony. Have a good day.
You too.
Well, that's it for the team this week, and thanks for joining us. If you've enjoyed the content, remember to subscribe and to share this episode on the app that you're using right now. Your reviews and your comments, they really help us expand our reach as well as our perspective. So if you have time, also drop us a note. Let us know how we're doing. For tips and tools to clarify your parent project, simplify communication with your stakeholders, and verify the professionals that you choose, you can find us on YouTube, follow us on Instagram and Facebook. Thanks again for trusting us. Until our next episode, behold and be held.
Thank you for listening to this Parent Projects podcast production. To access our show notes, resources, or forums, join us on your favorite social media platform or go to parentprojects.com. This show is for entertainment purposes only. Before making any decisions, consult a professional. This show is copyrighted by Family Media and Technology Group Incorporated and Parent Projects LLC. Written permissions must be granted before syndication or rebroadcast.